All right, let's get right into it. You know, this story, it's about so much more than just a little fee. We're talking about a real fight for what's right, one homeowner who decided to stand up to his HOA, and it all comes down to the surprising power that's just hidden away in the fine print.
So this is where it all begins, with what seems like a pretty minor detail. In this one condo community, if you had a one-car garage, you paid one fee. But if you were a neighbor with a two-car garage, boom, you're paying over $12 more every single month. And you just got to ask yourself, why? I mean, is that even legal?
And this is where our hero enters the picture. His name is Elmer Bittner. And yeah, you guessed it, he's one of the homeowners with that two-car garage paying that extra fee. But see, Elmer, he wasn't going to just sit back and complain about it. Nope, he decided he was going to do something.
And really, this is the whole thing right here. The big question that this entire case hangs on. Can an HOA just decide to charge different people different amounts for basically the same kind of home just because one garage is bigger? Well, we're about to find out.
You know, what I love about Mr. Bittner's whole approach is how smart it was. He didn't just get mad and fire off an angry email. He got serious. He went straight to the source, the HOA's own rulebook.
And get this, though. This wasn't some new rule. The HOA had been doing this since 1988. Can you believe that? For almost 20 years, people just paid it. But then, in 2006, a new law in Arizona kind of changed the whole game. And just a couple years later, Elmer Bittner decides to be one of the first to put that new law to the test. He files his petition, and that's when everything kicks off.
Okay, so to really get his strategy, you gotta understand this term, governing documents. Think of it like the HOA's constitution. It's not a list of suggestions. These are legally binding rules that spell out exactly what the association can and cannot do. Bottom line, if it's not in the rulebook, they can't do it. Simple as that.
And this just shows you how ready he was. Mr. Bittner came with receipts. His complaint wasn't just about his feelings. It was a rock-solid argument. He was citing their original 1985 declaration, a bunch of different amendments, even state law. He was literally using their own rulebook against them.
So when it all got to the judge, everything else just kind of fell away. The whole entire dispute was boiled down to this one simple question. It didn't matter what seemed fair. It didn't matter that they'd been doing it for 20 years. All that mattered was, what did the paperwork actually say?
All right, let's move on, because this is where the story takes a turn I did not see coming. I mean, you'd think the HOA, this big organization with lawyers and all, would come out swinging to defend a 20-year-old practice, right? Well, that's not quite what happened.
Just think about it for a second. What kind of argument could they possibly make? Maybe they'd claim bigger garages use more common resources? Or maybe that it was some forgotten rule they just rediscovered? What could their defense possibly be? The answer is, well, it's something else.
And here it is. This is a direct quote from the HOA's own lawyers. They just came out and said it. They admitted that there was nothing in their own rules that allowed them to charge these fees. It was a total confession. After 20 years, they basically just said, yeah, we had no right to do that.
Oh, but it gets even better. They didn't stop there. They went on to admit that nobody on the current board even knew what their own rules meant or how to apply them. It was a complete and total surrender. Absolutely unbelievable.
So, with a confession like that on the table, the judge's job suddenly got a whole lot easier, right? There was no need to hear arguments or debate fine points. The HOA basically walked in and made Mr. Bittner's case for him.
And so the final ruling came down from the judge, and it was crystal clear, no wiggle room at all. The Homeowners Association was wrong, period. And this victory wasn't just on paper. The judge ordered the HOA to pay Elmer Bittner back the $550 it cost him to file the case. So not only was he proven right, he got his money back too. The judge's final order was just two simple steps. 1, stop this illegal practice right now. And 2, pay Mr. Bittner his money back and do it within 30 days. It was a complete and total win for the homeowner.
So, you might be wondering, why are we talking about this one case from Arizona all these years later? Because the lesson here, well, it's for anyone and everyone who lives in a community with an HOA.
The big takeaway is really this: knowledge is power. An HOA isn't all-powerful. Its authority is strictly spelled out in its own rulebook. And Elmer Bittner won this fight for one simple reason: he actually read it.
So think of this as your toolkit, inspired by Mr. Bittner's playbook. First, read your documents. They're the final word on everything. Second, don't ever be afraid to question things that just don't feel right. Third, know that there are official ways to appeal decisions. And last, if you decide to make a challenge, document everything. Which kind of leaves us with one last really important question. After seeing how one guy used his HOA's own rulebook to win a 20-year-old fight, it really makes you wonder, doesn't it? What kind of powers or protections, or maybe even secrets, are just sitting there waiting to be found in yours?